The prime time now. Time for memorial lecture on the constitutional limits on taxation. That is all yours, sir.
This is Sri Rangaswamy, Sri Ramakrishnan, Sri G.V. Raman, Sri Anusha Srinivasan, distinguished members of the audience. In particular, I must mention Justice Ranganathan, Mr. Rajaratnam and Mr. Sitaraman. There's so many of you here, it's really going down memory lane. When Shivakumar called me a few months ago and asked me to deliver the lecture which is going to kickstart the centenary year, and he gave me a list of the past speakers, and I was very hesitant because I knew my own limitations. And I tried to tell him that, shall I get you some speaker from Delhi, shall I get you a retired judge who can speak and so on, but for once my advocacy completely failed. And he was absolutely stubborn and said that you will be the only person to speak. Then came the question of topic. I thought first that I decided I won't speak on the GST for the simple reason that it has been discussed a number of times and I didn't want to expound the virtues of the good and simple tax. And then I thought I would speak on the rules of interpretation, but then that would be carrying coal to Newcastle. So the only thing which I could contribute, which this audience may not fully know, will be the constitutional provisions relating to taxation. Because income tax I have learned from you, but at least as far as constitution is concerned, that I can say something. There's a famous Chinese author called Lin Yutang who said that if you want to be respected, speak something which nobody can understand. So with that caveat, I think I'll start my lecture. I'm deeply humbled that the speakers have equated me in some measure to the great D. Rangaswamy. I don't think the analogy is apt at all. But it is some measure of the greatness and goodness of the man that so many tributes are being poured upon him after so many years. And I remembered the title of Justice Chagla's autobiography, Roses in December. Actually the verse is, God gave us memories so that we have roses in December. So God gives memories so that we can remember the greatness of D. Rangaswamy in the month of December. Now, I chose this topic because we keep talking of taxation. Most of our livelihood is based on taxation in one way or the other, either audit or taxation. But few of us have really, I thought I can part with you something about the constitutional provisions relating to taxation and then deal with not individual articles but 3-4 topics which deal with this particular topic, and finally I will conclude with this retrospective amendment, and I want to explain what is the meaning of retrospective taxation vis-a-vis retroactive taxation. That is one thing which is going to be tested in the years to come. Now, one thing I must tell you as a student of law, that people say it's a long constitution, it's the longest constitution and so on and so forth, but having been a student for almost 4 decades, I think it's a magnificent constitution. No doubt it is based on the Government of India Act of 1935, but the way in which the fundamental rights were prepared, the way in which the directive principles were prepared, is a masterpiece of draftsmanship, and it is a document which has really kept democracy alive in a country of 1.4 billion people. If you look historically, most of the colonial countries, after they got independence, they had a constitution. In fact, for all of you know, if you see the constitution of the People's Republic of China, it guarantees freedom of speech, it guarantees right to property and so on. But we know what is the reality in most of these countries. But we have been one country which after almost 60 years have retained fundamental rights, and barring 1975 to 77, we have remained a vibrant, healthy democracy, and we must give credit to the Constitution. We don't know that every morning when we get up, we are free citizens of a great nation only because of this great Constitution. Now coming to taxation, it is not that the Constitution provided for taxes. A superb article on the history of income tax is contained in the British Tax Review by a gentleman called C.L. Lewis. In 2010, we celebrated 150 years of income tax. And in Indian income tax, first became necessary because of the Sepoy mutiny. The Sepoy mutiny of 1857 severely crippled finances, and they had to have some method of raising revenue. So they decided to have income tax, which had been introduced in England after the Napoleon Wars. There was outcry. They said, what is this? It's an English tree. It will never grow on Indian soil. Don't have income tax. And finally, to cut short the whole thing, they started levying income tax. And if you see the act, there were 4 schedules. Up to 200 rupees, there was no tax. Between 200 to 500 rupees, the tax was 2%. And those Indians, rich Indians who had more than 500 rupees per annum, had to pay income tax of 3% plus a surcharge of 1% which went for public work development. The biggest opponent to the income tax was the governor of Madras, Sir Charles Trevelyan, who called it a monstrosity. And many people said, a 4% tax, you will suck the life out of all of us and make us into corpses. That was the intervention. Anyway, the Income Tax Act was not such a big success. They ultimately collected only 2% of the total revenue could be generated through income tax. And there was expectation of tax evasion and so on even at that point of time. And my senior Ramamani told me a story that how would they make assessments? The collector would go on camp and I believe would sit in a tent, and this is there in Mr. Sundaram's book, I believe. The collector would make assessments. He'll call, say, Shiv Kumar, come along. Look at him, what are you, and okay, fine, your income is so much, you pay this tax. Then people realize that if you go with tattered clothes, the chances of your being taxed was less, when you could be subject to much lesser tax. So in one district, the collector went, a poor man came with a tattered coat, second man came tattered coat, third man came tattered coat. The collector noticed everybody had the same tattered coat. Then he found out that the Indian ingenuity, there was a man sitting outside who was hiding out tattered coats. So this was the background of the Income Tax Act. Finally then it came 1922 Act and 62. As far as central excise is concerned, you had before 1944 different acts. They wanted to levy, wanted money, they would levy excise on textiles. They'd levy excise on jute, excise on tobacco and so on. So in 1944, because of the reports of some British Commission, they said let's consolidate all the acts. And if you see the word, it's called Central Excises and Salt Act because it's an amalgamation of 11 or 12 different statutes. That's how the Central Excises and Salt Act came. Of course, all of you know salt was not taxed because of Gandhiji's Dandi March, but it continued to be Central Excise and Salt Act till Mr. Chidambaram changed the name to Central Excise Act and deleted salt. Customs Act, of course, you had from 1878, there's a Sea Customs Act, which was then replaced by the 1962 Act. Now we come to the developments in constitutional law. The Government of India Act of 1915 and 1919 did not contain express provisions regarding taxation. They called it revenue generating measures. For the first time, the Government of India Act 1935 created the Union list, which is called the Federal list, and then list 2, which is the provincial list, and demarcated powers of taxation. So the 7th schedule which we have, the Union list, the state list, and the concurrent list, are all legacies of the Government of India Act of 1935. Of course, there the union levies were 9 in number, today we have 13. You had 12 state levies, we have 17 state levies. So these are the basic provisions. Now one point you should note as far as the Constitution is concerned is that there is no tax in the concurrent list. There is no tax in the concurrent list. There is either a central tax or a state tax. For the first time, an exception came on the 1st of July 2017. So the GST, the Article 246A, enabled both the centre and the states to levy a GST. So this is the only example, and perhaps the biggest example now, where the central government and the state government can both levy GST. That's why when you see your invoice, we'll have CGST 9% and SGST also 9%, both the centre and state levy. So this became an exception to the rule that there could not be, there is no concurrent power of taxation. Now, I'll just go on to the controversial topics on constitutional limits of taxation. The most important, taxation is contained in Part 12 of the Constitution. And the most important article is Article 265, which says that no tax shall be levied or collected except by authority of law. 10-12 words. And the word law has been interpreted to mean parliamentary law. Now, one dangerous trend which is happening more and more is that there is delegated power of legislation being conferred upon the executive. If you take, for example, the Central Excise Act or the Customs Act, earlier, the Act provided the rates and so on, and it was left to the executive to grant exemptions or make some modifications in the rate, but not important rates. Now what has happened is, slowly in excise they said the executive could notify what amounts to manufacture. The most dangerous thing in the GST Act now is the power to make rules has been conferred with retrospective effect on the executive. It's a very, very dangerous power. I don't know what will happen if it is tested, but I'm just mentioning that we have now crossed the basic limit, because the idea is Parliament sets out the law and the executive fills up the gaps and implements the day-to-day administration, but the executive does not have the power of legislation. What is the control of the executive? And now in GST you find we're having retrospective laws from 1/7/2017, changing the rates, increasing liability, completely altering the landscape, which only Parliament or the state legislature could do. That is the danger which we are facing as far as this. So first limit of taxation has been crossed, that we are now giving to the executive entire power of making important laws. 15 days ago, a committee of the House of Lords submitted a report, and in England they have expressed the dangers of giving too much power to the executive. Now all of us know that every section contains a provision that all notifications shall be tabled before both houses of Parliament. All of you must have seen it. Every notification has to be tabled before houses of Parliament. That is called a tabling provision. I was surprised to learn it's a big report. It's on the net if you want, you can see it. The House of Lords reports on delegated legislation. In the UK, only 0.05% of the notifications were even considered by the House of Commons. So virtually the tabling provision becomes completely academic. I don't know what's the statistics in the Lok Sabha, but then you have a situation where you can make laws by notification with virtually no control by Parliament. I was talking to a senior IS officer when the Companies Act came. I told him, sir, what is this? There are some 480 places in the Companies Act to say, as may be prescribed. What will be the board fees? As may be prescribed. What will happen insofar as audit is concerned? As may be prescribed. Everything is prescribed. His answer was, sir, if Parliament is not working, what do we do? So that is another viewpoint which has been expressed, that we just can't wait for a bill to be passed before Parliament. We might as well take over the powers. That's a different problem. Now I'll go to the second part. I said that list 1, Parliament has the power to tax. List 2, the state government has the power to tax. On limits of taxation, what are the limits of a state government to levy tax? This was tested brilliantly by the Supreme Court in Gannon-Dunckelly's case in 1958. And I may tell the audience, not because Madras High Court is my mother High Court, but time and time again, I had the occasion of writing a chapter when we celebrated the sesquicentennial celebration, the 150th year of the High Court. They asked me to give a note on Madras High Court's contribution to constitutional law. So I was fascinated to learn that many judgments of Madras have gone to the Supreme Court. And without meaning disrespect to the Supreme Court, I found in many cases the Madras High Court judgment was equally, if not far better reason than what ultimately came in the Supreme Court. Take for example Champakam Dorairajan, the communal geo case. Very good judgment of the Supreme Court, but you must read the decision of Vishwanatha Shastri in the Madras High Court. Take L.T. Swamiyar's case, tax and fee, which we are now going to use very actively, is going to be discussed in the Sabrimala review. Please see the judgment of Satyanarayana Rao of the Madras High Court. Brilliant. Similarly, Gannon-Dunckelly I am coming to. This is a judgment of the Supreme Court by T.L. Venkatrama Iyer. Outstanding judgment, but equally outstanding is the Madras High Court judgment of Satyanarayana Rao and Vishwanath Shastri. So if ever you get a chance to do any cases on Supreme Court, try to go to the High Court from which the judgment came. It's often a learning experience. Now let me come back to Gannon-Dunckelly. Madras has the unique, it was the first state to levy sales tax. Rajaji's government levied the Madras General Sales Tax Act 1939, and you'll find that most states are replicas of the Madras General Sales Tax Act. Now, the desire for revenue is insatiable, it's just more and more. So, the government of Madras in those days simply said, sale shall include works contract. The definition of sale included works contract. Now, entry 54 of the Constitution, list 2 says, tax on the sale or purchase of goods. Sale or purchase of goods. Now, what is sale? The state government defines it. The state government defines sale to include works contract. This was challenged by Gannon Dankali in the Madras High Court. They struck it down. It goes to the Supreme Court. And it is very important to note what the Supreme Court reasoned. Justice Iyer said, Venkatram Iyer said, what is sale? He said sale is nomen juris. It's a term of law. Sale means a seller, a buyer, there is transfer of property in goods. Seller, buyer, transfer of property and price. These are the elements of sale. These are completely absent in a works contract because it's more like a bailment. I give you a job to do, you do the work, I will just pay you for the labor charges or the works charges. Now, the limit on taxation, which is part of my topic today, what Venkatramaya held was, you have the power to levy tax on sale. But in a classic judgment, he said, the state cannot expand its taxing powers by giving artificial definition to words in taxing entries. So you can't say sale includes works contract and expand your power of sale. This ultimately led almost 20 years later to the 46th Amendment. But the first limitation on state power is, if the state has the power to say tax on electricity or tax on sale or tax on motor vehicles, it cannot expand its taxing powers by giving artificial definition to these words. Now, before I go further, an outstanding judgment on tax is Justice Rumapa's judgment in Godfrey Phillips, where she lays down what are the essential features of tax. We keep saying tax, tax. What is the essential feature of a tax? Now, there are two essential components. One component is who is being taxed, and the second component is what is being taxed. Who is being taxed is, there are three parts: a person, thing or activity. There are three components of person to be taxed. It should be on a person, it should be on a thing or an activity. What is to be taxed is the subject matter of taxation, or what is called the taxable event. What is the event that attracts the tax? These are the two essential components. Now, on the limits of taxation, one point to remember, which Silva explains beautifully, is the difference between subject matter of tax and measure of tax or the quantum of tax. Now, once I've got the power, entry 49 list 2 says tax on land and buildings is the state government. So state government can levy tax on land and buildings. But what is the measure? They can levy tax depending on your rental income. But when they tax the rental income, that is, they say that people having more than 50,000 rupees per year will pay a higher tax, they are not taxing the rent. The subject matter is land and building, but the measure of tax is the rental income. So the point is, the subject matter need not be coterminous with the measure of tax. And it's again beautifully explained by the federal court in two cases. Now, I make a car and I sell it. When I sell the car, I pay sales tax on the sale price. Suppose I sell the car for 10 lakhs as a manufacturer. So I pay sales tax on 10 lakhs. I'm also required to pay excise duty on the car, and excise duty can be what? It can either be on, they can say cars below 2000 cc will have 1 lakh tax, cars above 2000 cc will have 5 lakhs tax, or they can have what is popularly called ad valorem tax. So they levy tax on the 10 lakhs. Now the question arose that when I'm levying tax on 10 lakhs, am I levying excise duty like a sales tax? And there the federal court held that you are levying tax on 10 lakhs, but one is on the activity of manufacture, the event of taxation is manufacture of goods, and the second is the event of sale, you are levying tax on sale. So there are two different subject matters, and they use the word, there is overlapping in fact, but there is no overlapping in law. There are two different levies. That brings me to the most burning and vexatious topic of today, that is overlapping of central and state taxes. And this problem started with service tax. And one of the constant problems we face, of course, GST has substantially reduced that headache, but there are still legacy issues. There are so many cases pending. One very unique feature of service tax is that entry 92C was inserted by the 88th Amendment to the Constitution. Surprisingly, that entry was never notified. And I can tell you, when we were doing this leasing service tax case before Justice Kapadia and Aftawalam, the Parliament website said it has been notified. But I had done a case in Kerala where we knew that it had not been notified. So finally they called a librarian, he spoke to the Lok Sabha Secretariat, and they said that website information is wrong, 92C was never really notified. Now why was it not notified? The reason is, once it is notified, then it becomes liable to be shared amongst the state. So throughout its life till it was replaced by GST, there was no entry in the Constitution, notified entry for service tax. It was levied year after year in the Finance Act itself. So that's part of service tax. Now coming to this overlapping in tax. Now in the same Godfrey Phillips judgment, Justice Ruma Paul and early judges also point out that there is no overlapping of taxes. Either the central government can levy it or the state government can levy it. How does the problem start? Now, as Mr. Rangachari mentioned, that the tax department gets more aggressive. You require revenue. You simply levy the tax and then let the person take it to the High Court and fight. Now, common problem started with software. Is software goods? Settled by the Supreme Court in Tata Consultancy, yes, software is goods. Now, software is goods. Development of software, what happens? They said it's a service. So on the same software I pay sales tax, same software I am demanded service tax, what happened? Luckily we succeeded through the Karnataka High Court, it's pending the Supreme Court. They said that once it is subject to sales tax, it can't once again be subject to service tax. And what is the reason for this? Because when I said there is no overlapping tax, either the central government can levy it or the state government can levy it. Now how do you divide this power? I told you that in Canon Dunkely they said state government can tax only what is mentioned in the Constitution. They can't expand their taxing powers. So entry 46 starts with tax on agricultural income. It goes up to entry 62, which is entertainment tax. That's all. What about Parliament? Parliament starts with entry 82, tax on income, and goes on to 92C, service tax. And there this Article 248 and entry 97, which talks of residuary powers of taxation. So if a tax is not mentioned anywhere else, it can be taxed by Parliament. Therefore, you have Gift Tax Act. Where do you get the power? ITO's Nazareth, they say go to 97. So if, and there's a very beautiful judgment of H.S. Dhillon versus Union of India, where I was told by my seniors in the Supreme Court that Settleworth finished his argument in 20 minutes. The question was, Palkila argued for 5 days on what is the scope of entries and so on, and Settleworth's argument was, if the matter is not in list 2, it is entry 97, and sat down. That virtually the argument was, if the tax is not mentioned in list 2, then entry 97 says residuary power of taxation, any matter not mentioned in list 2, Parliament can tax. So on that basis they upheld wealth tax on land. Now coming back to this, once it is entry 97, if there is no state tax, Parliament can levy. But the corollary is, if there is a state tax, it is forbidden territory for Parliament. Parliament cannot levy any item, any tax on any item which is covered by the state list. But unfortunately what is happening is, year after year, again and again, we are having a situation where Parliament is levying through the medium of service tax a tax on goods or services particularly which are already subject to sales tax or entertainment tax. We have got a matter in the Supreme Court. Now you take for example the set-top boxes and they are subject to entertainment tax, entry 62. Now Parliament is levying service tax, saying it's entertainment service. how do you reconcile the overlap? According to me, if it is an entertainment tax under entry 62, only state government can tax it. You can't go to service tax. It's completely forbidden. But one way which has been found out by the courts is the aspect theory, of which Justice Ranganathan is the author. And in the Federation of Hotels cases, for the first time they brought in this aspect of aspect theory. So now, there is a constitutional limitation on states which say you can't expand your taxing power. There is a constitutional limitation on Parliament which says that you can't levy a tax which is enumerated in the state list. Now what is this aspect theory which has been approved by the Supreme Court? In Canada, in 1890 or something, Hodge versus Queen, there's actually just a passing, because I've studied this again and again, there is just one passing sentence. It's at page 130 of that judgment in the law reports. It says that a subject can have one aspect in the central list and also have another aspect in the state list. That is, one law can have two different aspects, and that became the double aspect theory. Now, how was it applied by the Supreme Court? In Federation of Hotels, what was challenged was the expenditure on hotels where the rent was more than 400 rupees a day, which is at that time more expensive hotels. The argument was that this is basically a luxury tax, and on the same day judgments were delivered where the state government had levied a luxury tax on the hotels, that was upheld, and the central government levied expenditure tax, that also was upheld. How did the court do that? The court took the view that if you take hotels and they are more than 400 rupees or 1000 rupees per day, they may be luxuries. That's covered by entry 62. But there is an expenditure aspect which can be taxed by Parliament, and they said we have got earlier expenditure tax also is there. So all expenditure aspect can be taxed. Now how is this being developed later? I have, with all respect, I have written about it. I said that we should not go to the aspect theory. Our limit should be the pith and substance law, which is the real law as far as India is concerned. Because in Canada, the point is this. Section 91 of the Canadian Constitution talks of power of Canadian Parliament. It has 29 entries only. And if you see the entries, they are very generally worded. Public debt, law and order, peace and tranquility. You take our entries, they are more specific, very, very elaborately drafted. Take the state list in Canada, section 92, 16 entries, that's all. Again, generally worded. Regulation of business. Now, in that case, they have said that aspect theory will apply if a law has aspects of both central law and state law. I'll just give an example. Company law in Canada is in the parliamentary list. But surprisingly, insider trading was in the state list. Now you've got shares. Buying and selling of shares is the part of the life. I mean, shares are goods, they can be transferred. And every Companies Act will provide how shares are to be transferred. What are the restrictions? So that will come under Canadian company law. Now insider trading could be subject matter of state list. Then they said that look, the share aspect will be governed by the state law, insider trading is the state aspect, and therefore both the aspects are equally important, and that becomes the double aspect theory. But the requirement is the state aspect and the central aspect must be equal, almost equal. That is the aspect theory. According to me, in my humble submission, we have no place in our constitution for aspect theory. We must only go by pith and substance. And I'll give by two examples, and I've just got 10 more minutes. Take this tax on profession. I argued in the Bombay High Court for the C Institute and the architects, for chartered accountants, not for the institute, for the chartered accountants, against levy of service tax on chartered accountants. It came before Justice A.P. Shah at that time. He was before he came to Madras. If you take entry 60 of list 2, it says tax on professions, trades and callings. Any tax on profession can be levied by the state government. Now if I am a chartered accountant and if you levy tax on my profession, is it not coming under entry 60? So, but they levied service tax on chartered accountants. Now, taking the federation judgment aspect theory, the Bombay High Court said, entry 60 is tax on profession. That is just, you enroll in the bar, they can levy a tax. But when you actually render service as a chartered accountant, you're rendering service, and therefore I can levy tax on the service aspect. So enrolling as a chartered accountant is profession aspect, and this is service aspect. My limited intelligence can't comprehend the difference. And I'll tell you why. A very, very important judgment which Mr. Palkhiwala quoted in the Federation is Chinnapareddy's judgment in International Tourist Corporation versus Haryana. Entry 56 of list 2 says tax on carriage of passengers and goods. Now it's in list 2. So wonderful argument was raised. Since state government can tax carriage of passengers, they can tax only vehicles going on state highways. If the vehicle goes on national highway, you can't tax it. Can't beat the lawyers for ingenuity anyway. So this came up before Justice Chinnapareddy, but his observation in para 9 of the judgment is very, very important. Now, from the beginning we have been told, from the day in law college is told, all these legislative entries must be broadly construed. When you say tax on income, income must be widely construed. Navin Chandra Mafatla includes capital gains because income must be broadly construed. So every entry is broadly construed. So Justice Chinnapareddy says, if there is a tax in the state list, first ask the question, if I interpret it broadly, will the tax that is being levied come within that entry? Tax on professions, interpreted widely. Whether I enroll as a chartered accountant and I don't practice, or unfortunately I don't have any practice, or I enroll as a chartered accountant and I have a good practice, either which way I am carrying on my profession. So according to Chinnapareddy, if that word is so wide, it will be included in the definition and entry 60 will cover both. But the Supreme Court said no, and it went to the Supreme Court and we lost again. Supreme Court upheld the point and said profession is different, tax on entry 60 is different, and service tax is different. Last example on this aspect theory is leasing. Now after the 46th Amendment, leasing and hire purchase became liable for sales tax. They are popularly called deemed sales. Now suppose I take a vehicle on lease and I pay an EMI of 10,000 rupees a month. Now the state government levies a VAT on the leasing, and the EMI, as you know, will include the principal and the interest, and as the EMI goes further and further, the interest component reduces and the principal component will increase. But in Jam and Company, Supreme Court said VAT can be levied even on the interest component and not only on the principal amount, because that is part and parcel of entry 54. So we argued before the Supreme Court as to how can you levy service tax on leasing? Supreme Court said no. When you levy, say, VAT, it is on the leasing activity, but when it's through hire purchase, you're on the finance aspect of the transaction, and therefore the finance aspect can be taxed. According to me, the test is pith and substance. In pith and substance, what are you taxing when you tax a chartered accountant? You're taxing a professional. In pith and substance, what are you taxing in a lease? You're taxing a leasing transaction. It must come within those lists. It has no place. You can't justify such a tax by means of the aspect theory. Now, one more point I want to mention, which is again we are testing the limits of taxation. I've got just 2 points. One is extraterritorial operation and the other one is on retrospective taxation. Now our Constitution Article 245(2) says, a law shall not be invalid merely because it has extraterritorial operation. So the law is made in India, but its effects takes place outside India. No problem. Now what's the history of this? Article 245(2) is based on section 99. And before I go to 99, there is a very important judgment of Electronics Corporation of India, where Mr. Palkhiwala was arguing on 916 and 917 of the Income Tax Act, tax on royalty and fees for technical services. The question arose, can Parliament levy tax on activities outside India? In the old sales tax cases, they introduced the concept of nexus theory. If Tamil Nadu wants to tax something, that transaction must have a nexus with something inside Tamil Nadu. If India wants to tax something, it must have a nexus with something inside India. So Justice Pathak put a very nice question. He says, what are the ingredients which form the nexus? when can India tax a transaction where the operation is outside the territory of India? Unfortunately, Electronics Corporation withdrew the petition. It was referred to a constitution bench, but they withdrew the case. So this issue was never decided. Unfortunately, it came to be considered by GVK Industries, which utmost respect I think is an incorrect judgment, because in GVK Industries, again the issue of extraterritorial thing came up. The senior counsel for GVK says, I don't want to argue the case, I want to withdraw. But Supreme Court says, no, it's a very important question, we'll consider it. Which I think is not proper, because that's the opening part of the judgment. They say it's a very important issue. Now if it's a very important issue, you must hear the counsel for the assessee. He doesn't want to argue his case. But he said, no, I will take it up myself, and they decide the issue. And it is a judgment which has to be read, because there are a lot of sentences like constitutional topological spaces and so on and so forth. But what it says is, you can tax something if there is a nexus with India. I have no quarrel with that. Now come back to extraterritorial operation. You can make a law intra-territorial, but it can have an effect outside. Common example is, I am a resident of India. You can say I am liable to global income tax. So if I earn some income in US, I can tax it. So it's an Indian income tax, it has got extraterritorial operation, no problem. But let us see the history. 245(2) is based on section 99 of the Government of India Act 1935. 99(2) says, no federal law shall be invalid merely because it has extraterritorial operation outside British India. British India. Now British India is defined in section 311 of the Government of India Act to mean, British India means the provinces, that is the presidencies, the chief commissioners' territories like Oudh and so on and so forth, and this is most important, all territories over which the crown has suzerainty. Suzerainty is an international law concept which says, I have control over another state which is otherwise individually autonomous. So every princely state was autonomous, but the crown had control over it. That was British India. Now we simply deleted British India and made it India. Now the question arises, what is the difference between extraterritorial operation and extraterritorial legislation? And my thoughts to you and for all, because I want chartered accountants to consider it, is that we are crossing the limits of parliamentary power and trying to tax transactions which are completely outside India. We are not doing extraterritorial operation, we are doing extraterritorial legislation. And what are the examples? Take section 9. After Ishikawa Jima Hariva, Sinha judgment, Justice Sinha judgment, if you take the explanation added to N, what does it say? If the amount is coming under 915, 916 and 917, it shall be taxable in India. What? Whether or not it is service rendered in India, whether or not the person is in India at all. 195, the Vodafone amendment. It's the most shocking one. If you take 195, I've just taken a Xerox because I'm still not able to get over it. If you take 195, and this is retrospective, what it says is, the liability to deduct tax at source applies and shall be deemed to have always applied, and extends and shall be deemed to have always extended to all persons, resident or non-resident, whether or not a non-resident person has one, residence, place of business or business connection in India, or any other presence in any manner whatsoever in India. So even if you don't have a residence, business connection or no presence in India, you have to deduct tax at source. Now this is a very serious matter, because that's the reason why there are so many bilateral treaty arbitrations. Because you are now made people like Vodafone and Kane and so on and so forth liable retrospectively, and not just for income tax. You have proceeded against them under 195, 201 and so on and so forth. Now according to my submission, that this is a case of extraterritorial legislation. What is the difference? We know, we have learned fundamentals of international taxation, source rule, residence rule. Either the source must be in India or the person must be resident. For resident there is no controversy, it's a binary. Either he is resident or he is not resident. But source becomes slightly ambiguous. Some nexus must be there. But now we have developed a new contribution to international taxation. We don't have source rule, we don't have residence rule, we have payment rule. Any payment from India becomes liable to tax in India, and that, according to me, violates the constitutional limit, and it becomes extraterritorial legislation. Just imagine, I gave it when I spoke on this, and this was, in the Vodafone amendment they said, if it's a foreign share and the value of the share is substantially derived from India, the share shall be deemed to be situated in India. So if my company is in England, but all the underlying assets are based in India through a subsidiary also, then the company is deemed to be in India. Now that itself is a shocking provision because it's contrary to elementary principles of private international law. A share is situated where that company is incorporated. But India is the only country out of all United Nations countries which say that just because the underlying assets are here, the shares are deemed to be Indian shares. Now look at the consequence, and that's why explanation 6 and 7 was added. Maruti is a subsidiary of Suzuki. Suzuki derives value from Maruti. In fact, Maruti's turnover is more than Suzuki of Japan. Technically, legally, every time Mr. A sells a share of Suzuki to B in Japan, he is liable to income tax. Seriously, that is why they brought in explanation 6 and 7, that if the holding is not more than 2%, etc., you're not liable. Otherwise, everybody became liable to tax. In fact, after the Vodafone amendment, they issued notices saying your dividend is taxable here. Then people started laughing, they issued a circular, withdrew it. But this is the impact of extraterritorial legislation. And finally, I'll conclude by retrospective and retroactive taxation, which Mr. Rangachari referred to. What is the difference between retrospective and retroactive taxation? I've been studying this and it's been a fascinating journey for me. There is a beautiful book called Ben Juratovich he is a scholar whose PhD thesis has become a book. Europe bans all EU countries, no retroactive taxation is allowed by law. Our Supreme Court has said, rightly, Parliament has power to make retrospective laws known. But what is the difference between retrospective taxation and retroactive taxation? I'll give 4 examples and I'll conclude. One is, the law is prospective, but it depends on events which happened earlier. Take for example, suppose tomorrow Companies Act 2013 says, anybody who has been convicted for more than 2 years cannot become a director. Now, my conviction is before 2013, but I get disqualified after 2013. So, the law is prospective, but it takes into account transactions that have taken place earlier. Now, before I proceed further, there's a very good article by an Irish scholar, Northern Ireland scholar. He calls retrospective taxation as Janus-faced legislation. Janus is the Roman god of time who marks the beginning and end of time. That's why you got month of January. Janus has got 2 faces. One looks forward, one looks backward. So January means it's the new month. You look forward to the new year and also you look backward. So he calls it Janus-faced legislation. Now the first example I gave. Now the second example. It's a vanilla retrospective. I simply say in 2019 budget, income tax, which was 35%, will be deemed to be 45% from 2015. I simply raise the tax by 10%. That's retrospective. The third category is retrospective, which takes away a vested right. It takes away an existing right. Though the law doesn't say it's retrospective, because the law can say this law shall come into effect from so and so date. And I've noticed the Income Tax Act never says retrospective. It simply says it will take effect from the past year. Now, one case we are doing in the Supreme Court, Section 35. Hospitals, institutions are approved for 100% deduction by a committee headed by an eminent person. The committee chairman is a former Chief Justice of India, Justice Lahoty. He has approved certain hospitals, which in Gujarat, a 250-bed hospital costing about 300 crores. I have to collect, the exemption is for 3 years. Unfortunately for me, 18 months after my hospital started, 35(7) is introduced saying, this deduction shall not be available from 1/4/2017. Now what do I do? That's pending before the Supreme Court is part 1. Now here what happens is, this is an amendment. Though it doesn't say retrospective, it takes away vested rights. So it has got retrospective effect. And final category is what is retroactive taxation. Professor Fuller calls retroactive taxation a monstrosity, the most egregious and horrific form of retrospective legislation. What is retroactive taxation? So all these three categories, retrospective, you only make a law which takes past, which has effect earlier. But in retroactive taxation, you alter the factual situation. You change the factual situation. Now, take the Vodafone case. The Bombay High Court held, Justice Chandrachud's judgment, he said, if it's a plain case of sale of shares, and the share is a non-resident share, it's not liable to tax. Because the share is not in India, and the fourth part of 911 says, transfer of a capital asset situated in India. So if the capital asset is not in India, it can't be liable to tax. But Justice Chandrachud pointed out that $11 billion paid for Vodafone is not for the share alone, it is for the rights and options also. And he said, since it's rights and options, those rights and options are in India, that has to be valued, and he remanded the matter saying, find out the amount apportionable or attributable to those rights and options, call options, etc. in India. Supreme Court of course reversed it and said, it's a whole package, the share includes everything, you can't dissect or vivisect it. Now what did the Vodafone, why is it retroactive? The Vodafone Amendments section explanation 5 says, if a share derives its value substantially from assets in India, it shall be deemed and always be deemed to have been situated in India. So you alter the fact, a British share, a Cayman Island share, which was a foreign share till 2012, suddenly becomes an Indian share because you change the facts in the past. And all the Vodafone amendments to 247, to 214, to section 9, to 195, they completely alter the factual situation because you change the factual situation completely. For example, lawyers are not liable to service tax. Suppose tomorrow they say that lawyers shall be liable to service tax as chartered accountants and all lawyers shall be deemed to be chartered accountants from 2015. That is retroactive taxation. You alter the fact situation. I've been a lawyer, but in the eyes of law by deeming fiction, I become a chartered accountant from 2015. I'm an Indian foreign share, I become an Indian share with effect from 1962. This is retroactive taxation. And the point is, I chose this topic, I hope I have not put you to sleep on this constitutional law, but it's a fascinating topic. And as Mr. Rangaswamy put it, we are really crossing the limits of egregious kind of taxation. I am very sorry because there is no parliament should actually make laws like the Vodafone Amendment, make retroactive laws. Unfortunately, only one case on Section 9 is pending in MacLeod Russell. Nobody has bothered to challenge it. Why did you not challenge it? One person told me that suppose I challenge Vodafone and I succeed, they'll again retrospectively change that decision also. So I'll be back to square one. So what do? You go to the BIT. You invoke the bilateral investment treaty. Today India has perhaps the largest number of BITs in the world because of retrospective taxation. What is the solution? The solution is we have terminated the BIT. But unfortunately there are sunset clauses which show that treaty obligation will go. And if you see the model BIT, and I had occasion to be invited by the ministry to give a talk on the model BIT, and I think they must be sorry they called me. Because the model BIT, the bilateral investment treaty, now just 2 minutes of this investment treaties. After we opened the economy in 1991, we wanted FDIs. Now we make investment treaties. And in investment treaties, two clauses are most important. One is the FET clause, fair and equitable treatment, which is typically Article 3. And you got the expropriation clause, which is Article 5. Now, totally today, because we have done some research, 32 cases have been decided on taxation and BITs. 17 have gone in favor of the state, 15 have gone in favor of the SMEs. What happens is you can make your law. Nobody questions Parliament's sovereignty to make law. But once you sign a treaty, you concede your sovereignty to the extent that says yes, I will make laws, but I will not violate the fair and equitable treatment. I'll make sure that my laws are fair and equitable. Expropriation, Article 7. Article 5, it says I will not expropriate investors' property. So when I have a treaty with UK and they invest money in India, I assure them that my laws will be fair and equitable. What is wrong with that? But our model BIT says tax will be outside the treaty. Tax and subsidies will be outside the treaty. Our biggest problem is tax. Who will sign a model BIT will say I will not do it? And the other danger in the model BIT is Article 14, which talks of exhaustion of local remedies. The new model BIT says, before you go to an international arbitration, you must exhaust all the remedies. That is from the assessing officer to the Supreme Court. I must exhaust everything and then go to BIT. Now I asked a question. Suppose the SSC wins. Can the department go to the arbitral tribunal and say, no, Supreme Court was wrong? What about Article 141? Suppose the SSC loses in the Supreme Court, he invokes the BIT. He wins in the BIT. How will he enforce the award in India? What will apply, the BIT or the Supreme Court judgment? So now the point is, as Mr. Rangaswamy mentioned, we have not learned, if we are to attract FDI, if we are to attract this, then what is wrong in saying, what is wrong in assuring the world that my tax system will be fair and equitable, come to India, invest here. If there is something wrong, take me to arbitration. I have nothing to fear. Make it fair and equitable. But on the other hand, we are going beyond the limits of extraterritoriality, going beyond the limits of retroactive taxation, and also making India unattractive in the sense because of our tax laws. Thank you very much for your patience.